Thank you very much, Mr. Speaker. It's always a privilege to follow such an eloquent speaker as Mr. Gilmore. But can I just reassure him, despite what he may think, that in fact the college was not named after him. Although I was impressed about the way he managed to work Harry Potter into his speech there. Mr. Speaker, I just want to recap what a good job I think the Government Administration Committee did on this bill. The all-powerful Government Administration Committee, chaired by the Honourable David Parker, who did a sterling job there, very ably deputy chaired by Jackie Dean from the National Party, who's accompanied by Mr. John Hayes, always a beacon of light and hope. Mr. Hayes, he's a bit like the Waldorf to Alan Peachy's Stadler. He always brings joy to the room whenever he arrives at the Government Administration Select Committee. What was that? I thought that was quite good. Yeah. Mr. Speaker, well, I did enjoy the hearings on this particular bill. The Government Administration Committee took it very seriously. We heard, as we do all of the legislation referred to us, there's not very much actually that gets referred to the all-powerful Government Administration Select Committee. So it's always a privilege to have a piece of legislation that we can actually do something with. We did raise a number of concerns through the hearings of this legislation. The first concern related to the reasons, whether there was any justification for the wording in the bill being different to those in the Charitable Trusts Act. And so I put that question to the college. The college lawyers, who appeared before the committee several times, couldn't really give us a good quality reason why it needed to be different to the Charitable Trusts Act. They drafted the bill in such a way that it didn't link to what the Charitable Trusts Act said, and I thought there may have been a reason for that. They were unable to give us that reason. So we thought, in terms of the legal situation, it was probably safer to go back to the wording of the Charitable Trusts Act, so that if at any point there is a dispute about what this bill is intended to achieve, the courts will actually have a body of case law already there, because there is a strong body of case law around the Charitable Trusts Act already there, and we wanted to make sure that wasn't overridden simply by minor wording changes that the original draft of the bill contained. The committee also recommended inserting a new section to allow the governing body to use for another purpose excess income from trusts that generate more than is necessary for the donated purpose. And I think that's quite important. That's consistent with the provisions in the Charitable Trusts Act. And so we saw no reason why those trusts should continue to grow unnecessarily simply because the purpose basically doesn't require the amount of money that trusts are able to generate. So that was a fairly pragmatic and sensible thing to do. The committee was concerned, and we did have some quite robust discussion with the college around what some of the more redundant trusts involve, and whether in fact it would be fair to say that they were redundant. There was one trust listed in the schedules that we were given by the college that related to providing financial support to a student experiencing hardship. And I think the committee I put some pretty tough questions to the college as to why they actually needed to change that trust deed. Because I don't believe, to this day I don't believe, that the college could seriously put their hand on their heart and say that there aren't any students that would be experiencing financial difficulties and therefore that they couldn't dispense that money somehow. But they actually gave us a variety of reasons, which I was in the end, after we'd had quite a long discussion with them about it, I was in the end satisfied that there was actually justification for rearranging that trust as part of the wider rearrangement of trusts that they are doing. We were concerned that the bill as introduced was too general in describing a purpose for a trust as for the benefit of the college. For the benefit of the college could have included renovating the Grand Hall that Aaron Gilmore was talking about before, that he likened to the Harry Potter, to the Grand Hall in the Harry Potter books. And we thought, well, that would certainly be for the benefit of the college. It would have been inconsistent with probably been inconsistent with what the money was gifted to the college for in the first place. So we wanted to make sure that it was for charitable purposes, not simply for the benefit of the college, and that was one of the changes that we made by inserting a requirement for trust property to be used for charitable purposes. Again, I think that was a fairly sensible amendment. The committee also recommended inserting a new requirement for a new purpose of a trust, so as to be as close as reasonably possible to the purpose for which the property was given. So in the case of the example I mentioned before, supporting students who might otherwise be in financial hardship, if there are reasons why the trust as it stood could not practically be used for that purpose, we wanted to make sure that it was applied in such a way that it was as close as possible to that purpose. So it could be, for example, that a number of very small trust funds could actually be grouped together, a common purpose found for them that was as consistent as possible with the original trust funds, accumulating a more substantial sum of money so that it could be a more meaningful grant or so on. I think that was very sensible. We didn't want the college to be able to simply say, well, we don't think this is important anymore, so we're going to focus on our priorities, potentially against the wishes of the people who had donated the money. Because I think it's really important when we're talking about bequests and donations that we actually show good faith towards the people who make those kind of donations and bequests. I think if we create a precedent or create a situation whereby somebody cannot be certain that by giving money, whether to any kind of trust, that it's going to be applied for the purpose that they wished it to, they'd be more reluctant to do so. So I think we need to tread very carefully here that we don't actually create a precedent that allows a college such as Christ College to apply the funds in such a way that was never intended by the donor. So we did look at the legislation, the Anglican, Presbyterian, Catholic and Methodist churches and the way that they had brought similar legislation before this House, and we very much modelled a lot of our discussion around some of the provisions that were in those pieces of legislation to ensure that they were consistent. And I'll be interested to look at the supplementary order paper I understand the Greens are going to be putting forward. I understand that they want to put forward a supplementary order paper that strengthens some of the checks and balances in a similar sort of way to what the Methodist Church of New Zealand Trusts Act does, because at the moment the bill, even as reported from Select Committee, doesn't contain quite as fulsome a check and balance process as that piece of legislation regarding the Methodist Church does. So, Mr. Speaker, generally speaking, the Labour Party is quite comfortable with this. We did put some pretty tough questions, I think, to the college and during the course of the hearings on the bill. I was pretty comfortable that the college answered the concerns and the questions that we raised. So overall, I want to acknowledge Nikki Wagner, and she sat through, I think, all of the deliberations that the committee had on this particular piece of legislation. It was a test of stamina. I was impressed that she had the perseverance. But overall, so I acknowledge Nikki Wagner's contribution. I acknowledge the contribution of the other committee members. Overall, good piece of legislation, and I commend it to the House.